if we are not done, I hope Mr. Duprez is going to move faster because a lot of work was done on Tuesday. But if we are not done for today, can we break at quarter to 5? Is that in order, members?
For me, it is, Chair.
Yes, Chair.
Thank you very much. Honorable Breitenbach. Okay. No, I think there is no objection. And then the other housekeeping matter, which I just said before we start with our work. Members, I think you are aware that we did pass in the committee the Correctional Services Amendment Bill, and except the reservation by the Economic Freedom Fighters, all other parties did not have a challenge with the bill. Do we want to make declarations, or do we want a full-blown debate on the bill? The bill will be coming for debate on Tuesday.
Perhaps we should have a full-on debate, Chair. Just say.
Honorable Janji.
Chair, look, given the content and what the amount of work and what we're dealing with in terms of the bill, I think that Honorable Yako and their reservation can be done in a declaration form. So I would suggest that we don't go for a full debate, we go for declarations as parties. There's not much to debate about in it.
Thank you very much, Honorable Janji. It's a paragraph bill, honorable members. And in reality, all parties except that the EFF had reservations, and the reservations were based on the fact that Ms. Yako still has to consult with the party. But there were no general objections on the bill. So I'm not, the Democratic Alliance is Mr. Honorable Breitenbach in. Honorable Breitenbach.
I don't think she's in. Chair.
Yes,
Just,
Honorable Yako.
I think moving forward, for Honorable Janji's sake, I'm going to say the opposite of what I want to say, and then he's going to say the thing I actually want him to say, so that I can get things moving my way. That's just my plan moving forward to inform the committee.
What does that mean, Honorable Yako?
It means I'm going to say the opposite of what I want to say, and then he's going to say what I want him to say, because he's going to oppose me, which means he's going to say exactly what I want him to say.
True,
I am true.
No. So you are placing us on notice that even the things that you do not know what other members he is going to say, you are just going to oppose.
I might agree. I might agree just so he can oppose. Just saying.
Yeah, every time she can only articulate answer positions, I'm fine. I want to.
So you must advance EFF position so that she can advance ANC positions.
No.
Okay, no, I think we'll come back to it, honorable members. Let's proceed with the bill. Mr. Duprez.
Thank you very much, Mr. Chair. Mr. Chair, with regard to clause 3, the proposed amendment of section 12, the incest provision, you will recall that the committee had 3 options to choose from, and the committee chose the third option, which is the objective test with reference to the nature of the act that was performed with the child. Chair, maybe I should pause when I'm finished with a clause, maybe just to get an indication whether there are any questions, but I doubt whether this one will raise any questions. But I will pause nonetheless, Mr. Chair.
Members, because I can't see hands, just indicate if you want to speak, and if there's no one speaking, we'll take it as that members have no problem with the clause.
Thank you very much, Mr. Chair. Then moving on, we also cleaned up the sexual intimidation provision for the committee. This was the second option that we presented to the committee, and in short, it entails that all sexual offences will be included within the ambit of this provision. And then also just to mention, by the way, when the Cybercrimes Bill amends the Sexual Offences Act, then it will include those additional new offences as well. I think the provision speaks for itself, and the committee did deliberate on the provision. With your permission, then I will proceed, Mr. Chair. Mr. Chair, I'm going to skip the next couple of clauses because we didn't receive a final indication from the committee which option they prefer, but you will note that we have indicated that certain options were chosen in the interim. We'll see that later in the document. When it comes to a person who is vulnerable, I would like to point out one aspect for you. Under option 1 that was discussed on Tuesday, there is nothing new. The option remains the same. With regard to option 2, where we had that discussion of the LGBTQI plus persons, the grey that you see is the option as it was preferred by the committee, but we would like to propose, because it is still, the ambit of paragraph F is still very, very wide. So what we have decided in the meantime is maybe to propose to the committee that in order to maybe tighten this provision, or to maybe make the group a bit smaller, if I may say so, is to say that persons being cared for or sheltered in a facility that provides services to these members of the social group. And that is in line with, if we look at, for example, paragraph D and paragraph E, where we start talking about shelters or persons receiving care, etc. Especially, yes. Then what we would like to highlight to the committee is that on Tuesdays or after Tuesday's discussions, the committee at that stage indicated that option 3 would be the preferred option. And that is the note that I have made there on Tuesday, is that it's the preferred option now at this stage, or may I say at that stage on Tuesday. Proceeding further, we also indicated to the committee, and we've discussed this in the committee, we haven't received the final instruction here, whether the committee would want to adopt the option that was proposed, and that option provides for the whole retrospectivity concern. Proceeding further, Mr. Chair. Yes, these provisions and the options also speak for themselves. On Tuesday, the committee indicated that option 2 would be the preferred option in the interim, and that is where we address the very wide ambit of these provisions, which is similar then to the wide provisions of the definition of employer, to omit the requirements of access to persons who are vulnerable, or the requirement that someone may have access to vulnerable persons where they congregate or where they are present. Moving on then, Mr. Chair. This is the whole issue of option 1 was an attempt to make the information, limited information included in the National Register for Sex Offenders publicly available. The committee requested us to prepare option 2, which makes provision or aims to make provision for an application procedure to the registrar. We got the impression, Mr. Chair, that in the committee itself, the committee was still a bit concerned about any person, that it might be still too wide. And what we have done last night after meetings with colleagues, we would like to maybe just bring in this additional option 3, which I've prepared for the committee last night at the conclusion of our meetings. And with your permission, Mr. Chair, I'm going to run through the provisions just to give you an indication what could be done. In order to restrict the meaning of any person, the committee could possibly have a look at the term an interested party or interested person for that matter. So in the proposed new subsection 4, it would read, an interested party may apply to the registrar in the prescribed form to determine whether the particulars of any other person appear in the register or not. Then sub 5, the registrar in considering the application must be satisfied that the application is not frivolous or vexatious. Person who has submitted the application qualifies in terms of subsection 7 as an interested person, and the interested person acts in the interest of an identifiable vulnerable person. Sub 6 is merely a repetition of that paragraph B, where we say that after the registrar has considered the application and is satisfied that the application complies with the conditions referred to in subsection 5, the registrar may grant the request or refuse the request if the particulars, if confirmation that the particulars of an individual appear on the register may identify a person who was a child complainant or a person who is mentally disabled against whom the offence was committed. In paragraph 7 or subclause 7, it's proposed that the term interested person, sorry, Chair, interested person then be defined as a person who is a member of the family of or in a close relationship with a vulnerable person and who suspects that the particulars of a person who has regular access to or who frequents places where vulnerable persons congregate have been included in the register. And then clause 8 is a provision which the committee has already seen, and that's just dealing with confidentiality. I don't know whether you want me to pause here, Mr. Chair.
Yeah, yes, I think so. Members, do you want to say something on this one? Honorable Stephen Swart.
Chair, I quite like this additional option. It does limit the applications for interested persons, which is then defined. So it does take us, it does advance the bill. And so I appreciate this effort. Thank you.
Thank you very much, Honorable Swart. Honorable Mufuke.
Thank you, Chairperson. I think Honorable Swart is right. I just want to a clarity. An interested person Now, if maybe it's just not an interested person, it's an interested organization, what do we do?
Mr. Dupres?
I just wanted clarity on that because I am not sure because.
Mr. Chair,
I'm saying this because sometimes you find certain victims are supported by organizations that are working with them and they will monitor them forever. And then now when it comes to this, and when we say an interested person, I hear you and I really agree. But now even organization come in on behalf of that, whatever person, what will happen?
Thank you very much, Mr. Dupres.
Mr. Chair, yes. In principle, no objection to that. However, there might be a bit of a drafting challenge that I see coming up here, and that is, of course, the organization won't be a member of the family, but now the requirement is in a close relationship with a vulnerable person. But if we look at clause 6, subclause 6, we are talking about identifiable individuals. I don't know whether that might cause some challenges for us. What we can do is, and this is, I hate asking members question, Mr. Chair, and please forgive me for doing that, but I'm not sure at the moment how we are going to define that organization. The ideal would have been to say an interested person means a person or organization, but that is too wide. So we will have to try and limit that to an organization working directly with vulnerable persons. So I would maybe just like to get a response. Let me put it in for us so that we can see how it looks like. It will be, of course, a comma, but I'm going to use brackets now. Something to that extent, Mr. Chair. Or we could possibly even divide sub 7 up into sub paragraphs A and B to say that an interested person includes an organization. But we don't have any objections to the proposal itself.
Members, if we have a sub-paragraph which indicates that an interested person might include an organization, is there any objection to that?
Chair, I think the Honourable Mofokeng's suggestion is very good. It's something we might have omitted, and I appreciate the drafters, Mr. Dupre's insertion of an organization. It does broaden the scope of people that can apply, because you could have many individuals that are too vulnerable to assist people, and here you've got an organization that can act on their behalf. So if we can manage to bring in that, I think I fully support that. Thank you for the Honourable Mofokeng for suggesting.
Thank you very much, Honourable Swart.
Chair, Honourable Wilman Uhout has a hand up.
Honourable Nebo Dracham.
Me too, Chair.
Thank you very much, Chair. I just wanted to say I support the addition of an organization because it would assist a victim or a person who has no family, no support system. so you have, the person would have an option. So whether it's 2 subsection 7A, 7B, or it's in one, in subsection 7, it doesn't matter. But what is important is that it's in the bill. Thank you, Chair.
Thank you very much, Honorable Chele.
Yes, I agree. Me too. Thank you, Chairperson. I just wanted to find out in terms of A, where it says it's application is not frivolous or vexatious, Chairperson. We will explain that further when we do iloguzan in terms of application, because I would imagine, I don't disagree with it. It's fine, but I'm saying, are we also going to explain further as to what is it that would be considered as, maybe just to give an example, or I'm not sure if maybe I understand myself, because I can imagine if the application will be refused because the registrar just felt that this application, according to him or her, that it is frivolous or vexatious on those conditions, only from her own perspective.
Thank you very much, Honorable Chele. Mr. Dutris.
Chair, thank you very much. Mr. Chair, when it comes to 5A to C, these are proposals that we have included after we had internal discussions to try and establish or determine factors that should be taken into consideration. Now, unfortunately, and in many pieces of legislation, reference is usually made to applications which are frivolous or vexatious, but it's nearly like being a judge in a case. That requirement will have to be judged on a case-by-case basis, and it's difficult to provide you with a lot of examples in which it will most probably be apparent for the registrar that the application is frivolous or vexatious, and in other instances, not that easy to determine. So I must admit, it is a requirement that could be reconsidered, but we would like to receive the committee's guidance on which factors they want the registrar to take into consideration before the registrar then makes a decision whether to grant the application or not. I am sorry I can't give a clearer answer, Chair.
But the main aim of this provision is always to ensure that there is no abuse of the process. Is that not correct?
That is correct, Mr. Chair. And then, of course, also added to that, maybe just to limit the very wide ambit of the option that we previously presented to the committee. So the requirement would be now that there is some sort of nexus between the person applying, his or her concern, and the vulnerable person, which that interested person would like to protect. And then, of course, the person who suspected that the particulars of that person have been included in the register.
Honorable Chele, I know you might not be 100% satisfied, but what are your initial reactions?
I don't know. I'm not sure, Jebe. I don't even know what to say, because I think my point is exactly that one of abuse of power. We should not give people too much power to decide when maybe they can misuse that. I'm not sure myself. Thank you, Chair. But I was just raising it, just away.
I think it might. I think it might be difficult to list the instances or to have a definition of frivolous and vexatious. But I do also appreciate that these are terms that have been used extensively in most legislations. And it's possible, Mr. Dupreez, that there might be guidance in terms of case law as to the ambits that would be considered to be boundaries for anyone exercising that power, not to act in a manner that is unreasonable. Is that not correct?
We will have a look at that for you, Mr. Chair, and we'll try to at the next meeting report back. And if we find that it's necessary to define or explain these terms, we will do that. One can immediately think of an example of a person XYZ who regularly applies to the registrar, makes an application to the registrar in terms of these provisions, and certain pattern may evolve where the registrar might feel at some stage that no, the applications are becoming frivolous, the person is just a person who just wants to find out and does not really have a nexus to a vulnerable person or act in the interest of a vulnerable person. But we'll certainly have a look at that too.
Okay.
Chair,
yes,
Honourable Druchen.
Honourable Druchen.
Thank you very much, Chair. I would like to assist Honourable Jele, perhaps for the registrar, if they see an application as frivolous or vexatious, but the applicant perhaps does not view it in that light, maybe the applicant is very serious and the registrar sees the application differently. Perhaps there could be a way to appeal, or perhaps a way to ask for a hearing to get an explanation, perhaps from the registrar or the applicant. I don't know. I was just thinking of that to assist Honourable Jele's idea. Maybe there could be some kind of explanation because things are seen differently by other people. We don't always have the same opinion, and you know the registrar would deal with a number of cases as well. Thank you, Chair.
Thank you very much. I think Mr. Dupreez, can you take the two suggestions into consideration? The issue raised by Ms. Honourable Jele and the suggestion of Honourable Newbold, and prepare an option for us to consider.
Mr. Chair, I would like to respond immediately to the second proposal that was made, and that is why, and we expected actually that question as well. We must take into consideration that this is nothing else than an administrative action being taken. So if the registrar decides not to process the application further as a result of it being frivolous or vexatious, the registrar is duty bound to provide reasons for that. And then, of course, in terms of PAHIA, Promotion of Access to Information Act, which requires that a person exhausts all the internal remedies that they have available before they approach the court, that would mean that the registrar can be taken on an internal appeal to the relevant authority, which in this case will be the Minister of Justice. So, Mr. Chair, in that regard, the department is satisfied that it would not be necessary to write those requirements in here. I don't know whether I'll pause here, Mr. Chair.
Chairperson.
Honourable Mfuke.
I think agreeing with what Mr. Dupreez is saying, and also my colleagues, I'm thinking that he's correct that we cannot sometimes detail all the things, but something that we should be mindful of, that we have stressed, that here you can see the bills that are coming. We should have a technology working, because we don't need a situation where you find a registrar is the one who's the alpha and omega. You might find them in provinces differing, and sometimes others will take information out. There should be a situation where they log in a biometric or what and say that is Mr. Dupree or Mr. Swart or Ms. Mofokeng that dealt with this file, so that we can be accountable. I do agree with them and I understand their point. Maybe the implementation is the one that we need to tighten up. Thank you.
Thank you very much. But it's not clear in the bill as to the appeal mechanisms. I think that is where Honorable Jailer's challenge is. From where I'm sitting, I don't even know at what level is the registrar in this organization. Maybe if that can be explained, because from what Mr. Dupree is saying is that the appeal body from the registrar would be the Director General. Are we going to have a registrar? The registrar, will it be one central point, or are we going to have registrars decentralized throughout the country? And if you can explain that, Mr. Dupree.
Thank you, Mr. Chair. Mr. Chair, in terms of the Act itself, the Minister has the obligation to establish the register and then designate a registrar. Now, a registrar, the relevant authority for the registrar's decisions in terms of PAHIA is then the Minister. So, for purposes of PAHIA, one could argue that is the administrator who makes the decision, is the registrar, and if a party is aggrieved with the decision of the registrar, the internal appeal lies with the relevant authority, who is the Minister. The question that you have raised, Mr. Chair, with regard to centralization is provision is now made, and there is a proposal in the bill for the registrar. Mr. Chair, I'm interrupting myself now because I'm trying to think where that provision is, or whether we have included the provision. Mr. Chair, what we can do is we can insert a provision here that indicates that the registrar of the National Register for Sex Offenders is the only person who may receive and consider these applications. In other words, that it not be taken at a provincial level if there are such structures or sub-offices of the National Register for Sex Offenders in future. But we can provide a safety net provision for you in that regard to make it clear that only the registrar of the NSRO may receive and process these type of applications.
Okay, members, are we happy with that?
Chair, Chair, can we request that there should be more research into the issue of what is happening with the current register on the sexual offences, the children especially, those challenges that are there, we might actually come across them in future. I'm not saying that they will happen, as I say might, but let us look at what we had before as a challenge and say that we don't want to go that way again. You are correct to say, let us check who is going to be the registrar and where. And then it goes back to what was worrying my colleague, Honorable Matemba, and the clarity from Honorable Velma.
Thank you very much. Honorable Breitenbach, you had raised your hand. Honorable Breitenbach.
Thank you, Mr. Chair. It was an old hand. I was covered by the Honourable Mofokeng.
Okay. Thank you very much. Can we proceed? Honorable Jale, is that a new hand or an old hand?
No, it's an old hand, Chair. Thank you. I'm covered by Honorable Mofokeng. Thank you.
Thank you very much. Let's proceed, Mr. Dupreez.
Thank you, Mr. Chair. Maybe just to advise the committee that the term old hand might be a bit undiplomatic. One could rather refer to, is it the historical hand?
We will consider that.
The chairperson and I are old hands on this committee. Chair?
Yes, yes, yes.
Yes, Mr. Chair, we've gone through these two provisions many times. It doesn't solicit any comments or criticism, so we will accept that the committee now accepts them, and we'll also clean up this portion then of the bill for you in the next version of our working document. Yes, same here, Mr. Chair, with this provision.
Honorable Newwood, Jacqueline?
I hope this is not a dumb question, but can I ask if the registrar is handed fully to subs, if that is going to happen, then we discuss the details that we discussed now will obviously be applied there as well, right? That we discussed previously. So that part that we discussed there where Mr. Dupreez is now option 3. So all of that will then also apply if it is handed over to SAPS. Just wanted to make sure.
Mr. Dupreez?
Mr. Chair, that is a very important question being raised. The short answer, and permit me to do that because when we get to the second part of the document, we would like to explain to the committee what is intended with the second part. But in short, or the short answer is no, this provision will not apply in as far as the Criminal Record Centre is concerned. But we will explain to the committee precisely how that system works. With your permission, Chair, I'll proceed then. Yes, we've already covered this on Tuesday. It solicited no comments from the committee. That nearly brings us to the end of the first part of our document, Mr. Chair. This provision also didn't solicit any more comments from the committee recently or on Tuesday. This option was the option that the committee preferred on Tuesday, and that is the option that provides for persons who are entitled to apply for the removal, but who haven't applied for such removal before the implementation of this Amendment Act may still, after the fact, then submit an application, and the registrar must consider that application as if this Amendment Act has not commenced. It also didn't solicit any comments from the committee apart from the issue raised by one of your members that we should just, throughout our document, check the reference to 2020, which should be 2021 at this stage.
Sorry, Ms. Honorable Nivotahan, is that old historical new hand?
Historic hand, Chair.
Okay. Thank you very much. You can proceed, Mr.
Thank you, Chair. But Chair, once again, maybe if I may criticize, you can't refer to an old historical hand.
Oh, Mr. Dupree, I'm trying to accommodate everybody. Some of us still believe that the old hand is the easiest way to refer to an hand.
Please excuse me, Chair. I simply sometimes can't resist making the joke.
Okay, let's proceed.
Thank you, Chair. Yes, this is just a technical amendment which we explained to the committee. That is simply something that must be done, and that is to refer in the long title of the Act that a new offence has been created, and namely sexual intimidation. So that is something that must happen. And then also the amendment to the index of the Principal Act, and then we have the short title and commencement provision of the Amendment Act. Mr. Chair, when we, and yeah, I see, Chair, I must admit, maybe I should have clarified a few things for the committee at previous meetings, because I see we refer to at the heading of on page 25, the transfer of functions to the Police Service Criminal Record Centre. That might be a misnomer or create a misunderstanding. What is in fact proposed is that if the SAPS Criminal Record Centre will then become or will be required to issue certificates under in terms of Chapter 6, then the register, Chapter 6, the National Register for Sex Offenders, as we know it now, will cease to exist. And the system will be replaced by the system which currently runs in the South African Police Service, where they issue clearance certificates. That's the one important aspect to take into consideration. What we've already discussed in the committee, but I would like to repeat it with your permission, is that a clearance certificate reflects your entire criminal record. What the department originally was concerned about is the ambit of Chapter 6, which is limited to sexual offences. And the department was concerned that if a person, or the full criminal record of a person is divulged, it will take that process beyond the ambit of Chapter 6. But you will remember that the department, and I think we did it on Tuesday, is we came up with a proposal that to stay within the ambit of Chapter 6 and the prohibitions contained in Chapter 6, the prohibition should be restricted to sexual offences. So Chapter 6 will determine that a person who applies for employment should then submit a police clearance certificate together with the application for employment to the employer. And if such person has then a previous conviction for a sexual offence, the prohibition in Chapter 6 will then apply, stating that an employer may not employ a person who has been convicted of a sexual offence. So the prohibition will be limited to the sexual offence, but of course, that in short is the provision, is the requirement. So, and that is what we attempted to do in the second part of this document, is to indicate to the committee from the start which type of amendments will be required to Chapter 6 and other provisions, for example, contained in the Police Service Act as well as the Criminal Procedure Act, in order to give effect to this, if I may call it, a transition. Maybe I should stop there or pause there for a moment, Mr. Chair.
Yes. Members, your initial reactions? Honorable Nuvo Trahan.
I just need to pause and rethink after my first or my last question where the answer was no. There was a reason in the past why people wanted the sexual offense register. Now, after that, after that answer that I got from Mr. Dupré that said that no, then I think the sexual offense register must stay with the registrar and not move to SAPS. With the rise of gender-based violence, especially sexual offences towards children, I feel that if we do move it to SAPS, that we will let go of the severity of the crime, which is sexual violence. So I feel that it must stay with the registrar and not move. I'm not sure, Chair. I'm not sure. No.
Thank you very much, Honorable Yago.
Thank you very much, Chair. I think I want to agree with the previous speaker, because already SAPS is overworked at the moment, and they're unable to take on the workload, especially with regards to sexual violence and gender-based violence. So moving that register to SAPS, I don't think it's going to have the desired effect. Keeping it with the registrar, I think, is going to be more controlled and more safer. I'm not going to say that SAPS is prone to tampering, but I would rather it stay with the registrar instead of moving to SAPS. It would just complicate things in terms of them doing their jobs and us looking at the registrar separately.
Thank you very much. So you are expecting, Honorable Yago, you are expecting Honorable Janji to oppose you.
Not this time. Not this time.
Okay. Honorable Jale.
Chair, thank you very much. I think I agree with my colleagues on this one, Chair. It has to stay with the registrar. Finish. I'm not sure if I did say it correct when I say finish and clar, as if I'm saying I'm the last word on this, but I'm saying with the troubles and the good work or what the police are doing, I don't think this will really be a good idea for them also to handle this. This chairperson, to us, especially women, it's an asset. It's very important. We don't want it as women that it should be moved to police. They have their own issues. We appreciate they handle them properly. We are not saying they will be bad. We are saying they will be good also, but in this case, we prefer that it stays with the register. Please, Chairperson. Thank you.
Yes, I think you are appropriating to yourself dictatorial tendencies. Finish and clar is a dictatorial term.
Yes, Chair. That's why I did correct it. Thank you, Chair.
Okay. Honorable Breitenbach.
Thank you, Mr. Chair. I hear what the other members are saying, but the register hasn't been terribly successful in its current location. And I have no reason to believe that it's going to get any better. The police already have a system. It's up and running. It's quite sophisticated. Needs to be tweaked minimally to accommodate this information. And the information, the system can be designed to safeguard the information. And so I would approach it from the direction that we want to improve the police. I mean, the police are not performing well. So we need to fix the police, and that must be a goal that we have in mind. And with that improvement, this would be the logical place for this register. So it's not something that should be moved around either. So I would really support it being with I would support it going to the police. They already have a very sophisticated criminal record system. And the register has been an abysmal failure where it is now. So those are my views.
Thank you very much. Before, I'm not sure whether Honorable Yako, is it a follow-up?
Yes, it's a follow-up, Chair.
Honorable Jelly, is it a follow-up?
No, Chair, it's not a follow-up.
Okay. Honorable Nipo Trahan, is it a follow-up?
Yes, Chair, to follow up.
Okay. Let's start with Honorable Yako.
Thank you very much, Chair. I would just like to ask Honorable Breitenbach, when she says that the SAPS system is quite sophisticated and the one at the registrar has not been effective, is it not possible then to link the system that SAP has with the registrar so that they work concurrently together? So that the SAPS, when you get there, they add on, which then directly links to the registrar. Then wouldn't that make things a little bit more linear and controllable in that way? So that we've got a function that deals with the registrar, that we can, with the register, that we can keep and hold accountable for how effective it is, but then keep the police also aware of the updates as to sexual perpetrators and sexual offenders.
Thank you, Honorable Yako. Honorable Nipo Trahan.
Maleef?
Honorable Nipo Trahan.
Sorry, Honorable Chair. Honorable Breitenbach, yes. Previously, we did say to transfer it to the police, and we were in full support of that. But after what was said today, I want to say that is why that's why I wanted that amendment to the bill. So I'm asking Mr. Dupree, is there somewhere that we must add into the bill to improve or stake up the current sexual violence register, because as I said, it's not working. So we need to make amendments now to strengthen it up, okay, to tighten it up. Now, the previous options that we added, 5A, B, C, 6 and 7, when I asked if it is transferred to the police, will it apply? And the answer was no. So, I mean, it can't be applied to when it is transferred to the police. So those submissions that we made, those amendments that we made, so interested person and all of that, it's not going to apply, or an organization. So the answer was no then. So now so what about all of these amendments that we made and all of those things too? So if it's transferred, it can't be applied. And then Sorry, Chair, my network was off. I think, yeah, that was my question. Yeah.
Thank you, Honorable Mufute.
Chairperson, listening to Honorable Yako, Honorable Breitenbach, Honorable colleagues Velma and Honorable Nomathemba about this subs, I want to suggest that and maybe check with Mr. Dupree, is it possible that we can link so that when police is having them, then we know even justice is having that. But there should be a control somewhere. I don't know how, but we cannot leave it only with police. I agree with them. But also the challenges that we are having currently with the current register is a problem. That cannot be something that we leave open.
Mr. Dupree.
Thank you, Mr. Chair. And I'm going to answer the question that was raised here first. And I apologize to you, Mr. Chair. I misunderstood the question because I was under the impression the question was asked whether a provision like this will be applied to the SAP 69, the Criminal Record Center itself. I said no, because this is what in fact happens currently. Any person, meaning any person, may apply for another person's clearance certificate. However, what is important, and I think a reference was made to the sophistication of the Criminal Record Center, and it is so. It's important to remember that the only form of positive identification in South Africa, insofar as a person's previous convictions are concerned, is by the Criminal Record Center because they use fingerprints. That's the most reliable form of identification in the country. So the question, even if a person then changes their names or their identity, they can't change their fingerprints. So if they do have a record, it will show. So that's the first important thing to remind ourselves. What we would like to clarify is if you look at Chapter 6 currently, it does a few things. It creates the register, but more importantly, it defines for us who are vulnerable persons. Currently, of course, children and persons who have mental disabilities. And together with that is the prohibition. The prohibition is actually the most important part of Chapter 6. And the prohibition is, it relates to the protection of our current vulnerable group, and that will be extended to include additional vulnerable persons. If you look at the Criminal Record Center's operations and the issuing of clearance certificates, if the register is closed down, Chapter 6 will be left with the definition of vulnerable persons and the prohibitions in respect of employment, etc. But in as much as the functions of the Criminal Record Center are concerned, it will be business as usual. Anecdotal information that we have available is that they issue around about 1 million clearance certificates per year. So if reference is made to a sophisticated system, that is entirely correct. With regard to the proposal or the request that the two systems should be linked, that is, I know that there was in the past, and I'm speaking under correction, it might be much better to ask the registrar, but I'm aware of the fact that at some stage attempts were made for the two systems to speak to each other, but it amounted to a lot of money. I don't have the figures available but we can't see whether it will serve any useful purpose for the two systems to talk to each other, because the source of your convictions, of your criminal convictions, is the courts. And in terms of the ordinary processes, they inform the Criminal Record Center of convictions, so that a person's criminal record can be updated. But at the same time, the current Chapter 6 then places obligations on the clerks of the court and the registrars to update the registrar. So once again, it's difficult to see precisely what the advantage will be for the two systems to speak to each other. In all honesty, the protection afforded by Chapter 6 will remain in Chapter 6, and the obligations on employers will remain. The extension of the ambit will relate to the expansion of who will be regarded as vulnerable persons. Mr. Chair, I'm with your permission going to interrupt myself and maybe ask Ms. Huerta. I see that she indicated that she would also like to mention something at this stage. Thank you, Chair. Okay.
Chairperson.
Chairperson and all the members, and thank you.
Before you can come in, Chairperson.
Honorable Taylor.
I wanted, because what I was going to say, Chairperson, it was also linking with what Ms. Botha said sometimes days ago when we were dealing with this. So I wanted Ms. Botha once also to, when she responds, so that she can include that. Isn't it that when we asked this question of transferring this register to the police, there was a feeling that when it goes to the police, it will just be treated like any other criminal cases that the police have. That's my question, Chair. Because my concern is why I'm asking that question. Chairperson, the issue of money that is going to be expensive, it cannot be equated with the lives of women that have already been killed and died on this issue. So I was thinking that if we are saying it's going to be expensive, how expensive when it compared to life lost? Thank you, Chair.
Ms. Porter.
Thank you very much, Chair. And I know it was a long week, especially for the Portfolio Committee, and I trust that by what I'm going to say, I'm not going to confuse you. But I feel that it's very important that we take into account a few aspects when the committee must make the decision of whether the register must be retained, or whether from now on the employers must get a clearance certificate from SAPS directly. The first thing is what, and Mr. De Prier did raise or referred to that, and that was the issue of where the information was coming from that is presently in the register. It came from SAPS, and you may recall that in our present act there is a retrospectivity effect insofar as the names of perpetrators to be included. And that was problematic, especially because it was limited to children and mentally disabled persons. And normally on your SAP 69, they don't indicate this person was found guilty of raping a child or a mentally disabled person. So that information was not relatively available. So, and the registrar was also dependent on the police to get that information. According to what we understand how it works now, also the clerks of the court are supposed now to in respect of new convictions, to send that to the registrar as well. But what I want to draw your attention to is, and I want to say in the beginning, Chair, I'm not pro-perpetrator. Please don't see it in that way. I want us just to make sure that the committee has, in my view, all the information that it needs to take an appropriate decision whether the register, it will be the end of the register, or will we go the SAPS route. The one thing that I want the committee to think about is that there are, according to our information, although there might be not many, there are already perpetrators who served their sentence and whose name has been removed from the register. So, and you remember what we promised them. We promised them to say, if you serve that particular term of imprisonment, depending on the type of offense, then after so many years, your name can be cleared, and you know what, then you can become a teacher again. So that is the one thing that we will have to take into account, because what our understanding is, and the police can confirm it, the mere removal of my name as a perpetrator from the register does not mean that offence is removed from the SAP 69. It's still standing there. So I try to indicate to you with the dilemma that we will just have to think whether we should, if the decision is that we go this SAP 69 route, that we have to think how are we going to deal with these people. Then you sit with other people that are almost there. They're almost finished their period of imprisonment, and now we change the rules of the game. All of us fully agree that it is Parliament's prerogative to change the law according to changing circumstances. So we mustn't ever forget that. But despite that, I think it's important then to look at that issue is about these persons who are almost like, maybe they've already qualified, but they have not asked for whatever reason for the removal of the name. Now, the implications of the first instance is where I said, I've done something wrong. My name was on the register, and the registrar she removed my name from the register. Now I can become a teacher again. If we revert to the SAP 69 situation, that, according to our understanding from people who we've consulted since yesterday, is that the 69 will still reflect that sexual offences register. What is the implication of this? The implication is merely that if the principal of a school looked then at the clearance certificates issued by the SAPS, then the principal will see that this person has been found guilty already of some kind of sexual offence, although he has already served out his sentence. Now, one of the issues that was raised during the comment stage already was, how do we regard this prohibition, or let me say, this obligation, that if you're found guilty of a sexual offence against a child and a mentally disabled person, whether, if that is the case, let me just think, how can I put it, is so that I don't confuse you, I will be with you now. So you go back to that question and then say, is how would that affect the situation? In my view, is if we then opt for the other option, then it will mean that that person who applied, who served in sentence, because they say, some people argue, that's what I wanted to make the point here in the comment stage, the prohibition to be a teacher, and I use the teacher because that's the easier example. The prohibition in the Act that you can't be a teacher for a certain period of time, depending on the nature of that offence, that forms part of your sentence. It may well be that that sentence is not a sentence imposed by the magistrate, but it's imposed by Parliament, the legislature. So then what you sit with a situation that I'm sitting with my removal certificate, and now because it's that offence is still on my SAP 69, they're going to turn away my application. And I'm not saying, this person must get the job. All that we know is this person then, in terms of the situation as is, has the right to be considered as a potential applicant for that position. And I'm not saying this that please understand that I say we shouldn't go that route.
Ms. Bob, I think for you to be in a position to assist us, I think let's package the information differently, because now you are giving us a lot of information. Let's first address the issue of the register, whether it should be with the SAPS or with Justice. And then I think we can, because now I think we're getting a lot of information, and it might confuse us. I think let's take it step by step.
No problem. Thank you, Chair. And I'll hand over then to Mr. De Pre. He will then continue with the presentations and the questions. Thank you very much.
Okay, Honorable Newbold Drachen, followed by Honorable Breitenbach. Okay,
that was an old hand, Chair. Apologies.
Okay, Honorable Breitenbach.
Thank you, Mr. Chair. I just want to revisit the issue of the location of the register. And I understand the concerns of the members. I think what's perhaps not 100% clear is that I agree with Mr. De Pre that I don't see, in answer to the Honourable Jaco's question, I don't see the immediate benefit of having the two systems talk to each other. I don't think that we need two systems. I think one is sufficient. And what happens in practice is you prosecute somebody, they get convicted, and then prior to sentencing, the police produce what is called an SAP 69, which is the criminal record of the accused. So it would contain all of the previous convictions of the accused. And that gets presented to the court in aggravation of sentence, and then it goes to the orderly in court. And the new sentence is added to it. So it's an immediate capturing of information. It then goes to the police at their SAP 69 register, where the register is updated. So there's very little opportunity for a broken telephone kind of information loss. It's very immediate, and it's very secure. Now, the SAP 69 system is a sophisticated system. It compares well internationally, and so it offers that guarantee. The information is available upon request and upon good reason. So not just anybody can wander into the police and demand information from the SAP 69. But if you have a reason for requesting the information, then it is available, and provision can be made for that. So I would urge the members to just think about it more carefully. The register of the police is the most sophisticated register that there could be at the moment, and it is the most immediate fashion of capturing information and keeping it secure. And again, I agree with Mr. Dupré. I don't see an immediate benefit in having the two systems talk to each other. So, as the matter leaves court, it's immediately captured. It's a very useful, very immediate solution to that problem of a lapse of information. Thank you.
Thank you very much. Honorable Breitenbach, what is the challenge with the current register?
Oh, Mr. Chair, the current register is proven to be unsatisfactory in a variety of forms. It's not up to date. It has many mistakes in it. I think that's common cause. At some point, information was duplicated on it for some reason. I'm not sure why, and so it's really a shambles. The current register is really a shambles. It's unreliable. It's incomplete. It's incorrect. And all of those things pose great risks on both sides of the spectrum. It's also not necessarily as secure as one would like it to be. Whereas a register held on the police system answers all of those questions. It ticks all of those boxes. The current register is, with the greatest of respect, in my view, not a register worth having.
Honorable members, I think I would suggest that given the information we have received, honorable members, we have to digest it, because I think even when the bills were first presented to us, there was an admission to the fact that the current register is not effective. But I would really ask that members digest the information that we have received properly, and then when we come back, we can come back with considered views on this issue, and so that we can have a solution that would not undermine the fight against gender-based violence.
Sorry, Mr. Chair, I forgot to mention one thing. May I just mention it?
Yes, we can.
It may be helpful. The added safeguard with the police, of course, is that every criminal case has an investigating officer. And it's also the duty of the investigating officer to make sure that the SAP 69 gets updated. So there's a belts and braces approach. It goes via the route of the court orderly on the SAP 69. It also goes via the front of the docket, where the prosecutor fills in the front of the docket, via the investigating officer to the SAP 69. So there's a much better chance of it being correct and timeously updated.
Thank you very much, Honorable Breitenbach. Honorable Nibo-Trache.
Thank you very much, Honourable Chair, for allowing me. I do have one question, which is a big concern, a worry to me. For paedophiles, for example, from overseas, who make their way to this country, they've been charged and found guilty overseas, but then they come here to South Africa. I want to know well, and and they target children specifically. So I would like to know that, does the SAP system have any way of getting those people, having the records of those people, or do they only cover South Africans who have committed these crimes? Thank you, Chair.
Thank you very much, Honorable Jelle.
Thank you, Alison. I just want to find out, Chair, if it's not going to be too much, can we get anyone or those people who are responsible for this, if it's not going to be too much, for this registrar now to come and answer to these questions, because it will be, to me, it's like we have to, like you say, Chairperson, we have to look on all options, and also even the current one, we need to know why is it not working? Why are these problems? Because they were given that responsible to do that for the community. And we want to know before we can take a decision, Chairperson. And I'm not sure if maybe that will be too much. I'll be asking too much.
Yes, no, thank you very much, Honorable Jelle. Because I think before we move to the drafting stage, we must have a correct appreciation of the functionality of the system before you can legislate on it. And I think Honorable Breitenbach has taken us through some of those issues. I think it would be important that as legislators, we fully understand the whole process and the challenges before we can say we legislate, because it will not be ideal to legislate on something that we don't have a full appreciation of. I do think that Honorable Jelle, your point is should be understood in that fashion, that we would want to understand it much more better before we can talk about legislating around it. I think it does make sense. Honorable Breitenbach, followed by Honorable Yako.
Thanks, Mr. Chair. I just wanted to answer the question of Honorable Nevadrachan. Yes, there is a system that is internationally acceptable. Interpol runs a facilitation system where the different police departments around the world can access that information relatively easily. So such a system does exist.
So, Honorable Breitenbach, does the current register that we're talking about, not the SAPS one, does the current register have all those sophistications?
No, certainly not.
It does not.
Interpol is the international police organization,
yes.
And it's available only to police departments around the world.
Thank you very much, Honorable Breitenbach. Honorable Yako.
Thank you, Chair. No, I just wanted to agree with and second Honorable Maseko Jelle on her request that we have all the different entities, the registrar and the rest, come and inform us so that we can make an informed choice, and also maybe decide on how we want to oversee the current registrar if it's not functioning well as it is right now.
Thank you very much, honorable members. We will try to have that as soon as possible. The program is quite packed. It should not be a very long session to have, I think, both the registrar and the SAPS urgently presenting to us on that particular issue before we finalize the bill. So we would make those arrangements. Honorable members, it is raining this side, so you might experience some difficulties from my side, but please be aware that it is heavily raining this side. So can we come back to this issue as soon as we can? So we will, after this meeting, ensure that we act on this issue so that we can have that presentation and so that we can finalize this bill as soon as possible. Is that agreeable, members?
It is, Mr. Chair, and I just want to tell you it's a lovely day in Cape Town. The sun's shining, it's warm. And
it is, yeah. I agree.
No, Pretoria North is bad. It's bad today. No, thank you very much, Mr. Dupres.
Mr. Chair.
Mr. Dupres?
Yes, Mr. Chair.
So you heard what we have just said, yeah?
I have.
Yes.
Mr. Chair, I would just like to mention to the committee, and I don't want to get down into the details thereof, but either way, whichever way the committee decides to go, it will require of me to prepare amendments, and when one prepares amendments, you must be very, very careful, and you have to, your product must be 100% correct. So, and that takes time, Chair. Unfortunately, even if I work 24 hours a day, it is going to take time. So I'm requesting at this early stage your indulgence, please, Mr. Chair. There might be a slight delay in the preparation of those amendments. Thank you, Chair.
You talk about amendments or comments. I can't hear properly. There is noise because of the rain, Mr. Dupres.
Yes, Chair. I'm referring to the amendments, the amendments that must be approved by the committee. I'm merely saying that please just take into consideration, even if I work 24 hours a day, there might be a slight delay in the preparation of those amendments.
So those will be occasioned by us requesting further information on the register?
No, Chair.
Or generally?
No, Chair. I'm just thinking ahead of what I still need to do, and that is once the committee is satisfied with this working document, I will have to transform this working document into amendments to be approved by the committee.
Yes. No, we are quite cognizant of the pressures you are working under, Mr. Dupres, and we would not be unreasonable. We will have to keep lines of communications open, because if we put you under unreasonable pressure, then you will bring something that is substandard, and that which will be substandard will not reflect you, it will reflect us. So we will keep communication lines open. We will not be unreasonable. We want a quality bill that can assist the nation to fight this gender-based violence. So we'll be working. Yes.
Thank you very much, Chair. And then I would just like to know, I suppose that the committee secretaries will then get into contact with SAPS and the registrar to attend the next meeting of the committee.
Yes, that would be done.
Thank you very much, Chair.
Yes. Do you have any other issue that you would want to raise with the committee, or are you done?
Mr. Chair, I think I'm finished for the day. I don't know whether the committee would like to ask any other questions, but thank you very much once again for your time and the questions that have been raised. And maybe just as a parting, sorry, Chair.
Thank you very much, honorable members. Are we happy with all the comments and the amendments that were presented to us? That Mr. Dupres can start cleaning the documents for presentation to us.
Chairperson?
Honorable Mufokeng, followed by Honorable Livodrachen.
Thank you very much. I think we appreciate the honesty that Mr. Dupres to say that, please, I'm not going to be able to complete, very quick, because I know that a number of people and the citizens thought that you will actually adopt the bill by the end of maybe March. But it's very clear that because we need quality, things might not be the way everybody is expecting. Noting all the challenges that are having, appreciating that we need more information, that is highly appreciated. And I'm thinking that we really need to thank him for that. And for today, all the things I think are covered, even if there are a lot of clarities. Thank you there.
Thank you very much.
Chair. Supported.
Honorable Jailer, you started by appropriating to yourself dictatorial tendencies. Now we are graduating to the next level. Honorable Jailer.
No, as Keys Chair and the members, Chair.
Thank you. Honorable Nivo Drachen.
I would just like to second what Honourable Mofokeng King said and thank Mr. Dupree. I just want to request one thing. What you typed, all of those things that are added, draft 5, I think that's draft number 5, if that can be then sent to us. I would like to see all the things that you typed in there. Thanks.
Thank you very much. Honourable Breitenbach.
I'm sorry, Chair, it's an old hand. Sorry, I'll take it down.
Okay.
Mr. Chair, may I?
Sorry, before Mr. Chairperson, something that I think I don't know when are we going to get time to get a bite again on that part of the spiritual abuse. I think I saw a note or whatever information from Mr. Swart, Honorable Swart, and I was thinking that we should not leave that until late, that we need to get a bite again on it. Thank you.
Yes, thank you very much. I think that is part of the domestic violence bill.
Mr. Chair?
Mr. Dupree?
Sorry, I rudely interrupted you now. I thought that you were going to conclude the meeting. Mr. Chair, may I just, please indulge me, as a matter of just purely interest, in sign language, how do you sign my surname? And it's a question to one of the members of your committee.
You sign with your pen. Sorry, that's flippant.
Honorable Nevo Drahan, do you want to respond?
Well, normally, yes. We pick a sign name based on any facial features. I haven't seen you, not even on the screen, so I don't know what you look like. So normally we just finger spell your name for now.
You have a sign for a very handsome person. Mr. Dupree is a very handsome person, so.
Some people refer to me as the voice, Mr. Chair.
No, thank you very much. Thank you very much. Let's go back to the issue raised by Honorable Mofokeng. Yes, as I was saying, the issue of the spiritual abuse, my understanding is that it falls under domestic violence, and
Yes.
we'll be dealing with that on Tuesday after the sitting. To get Mr. Who's the one who's dealing with domestic violence? Mr. Robertson. Yes, on Tuesday and then on Wednesday. But we have just been informed that there will be 3-line whips, which we must factor in. I'm not sure how are we expected to conclude these bills with all of these issues happening. If I remember well, I was informed that on the 9th, 11th, and 16th of March, we are all expected to be in the House. It will be 3-line whips. So, which might affect the Tuesday sitting, depending on how long will the sitting last. But it does really affect our program as the committee. because we are expected to have these bills, if everything goes according to plan, at least by the 19th. Yeah, also on the 19th is a 3-line week. At least by the 19th, that we should be done. If we are not able to, we should be able to approach the House chairperson and advance the reasons as to why we would not be able to pass these bills. One of the reasons, I mean, already we have the issues that are raised by Mr. Dupreez. We will monitor everything to ensure as to how far are we progressing with the bills. But at no stage are we prepared to compromise quality just to meet deadlines. We would not do that. So we have these 3-line whips, and on Tuesday we will start early with the public, in fact with the interviews for Human Rights Commission, and then evening or after the sitting, then we will proceed with domestic violence, and then even on Wednesday we will continue with the interviews for South African Human Rights Commission, and then in the evenings we will continue with the domestic violence. Hopefully that would take us somewhere, and then we would be able to have an assessment as to whether we would be in a position to pass these bills this term. Thank you very much, Mr. Dupreez and your team, for your hard work. I know that you work through the night, you work during weekends to ensure that vulnerable people, children and women, live a life free from all these threats that you are trying to deal with. Thank you very much for your dedication, for the whole team, for your dedication. So we would contact you soon as to when are we going to have that presentation from the registrar and from SAPS, and also allow you space to work on the document so that we can have a document that can be ready to be adopted by the committee. Members, thank you very much. When you were still struggling with connection, Honorable Breitenbach, we were discussing an issue about Tuesday, because on Tuesday we must debate in the House or adopt the Correctional Services Bill. So there are two views. One view says that because generally we all agree on the bill and it's a paragraph bill, with the reservation of the EFF, that we just need to have declarations. But there is a view from the EFF that now, irrespective, we must have a full-blown debate. We must bear in mind, members, that the longer we sit in the House, it means we must still come back in the evening and work through the night to deal with committee work. The lesser time we spend in the House, we're able to come back earlier and to deal with the processing of the bills. So that is what we were discussing when we had connection problems.
Thank you.
Yes.
Thank you, Mr. Chair. I certainly support declarations and not a debate.
Not a debate.
I was putting a spanner in the works, but the declaration is fine. I was just putting a spanner in the works. That's all.
Nothing worse than having a debate on it, really.
Thank you very much.
Thank you.
I'd rather go and have my other knee done.
Yes.
Honorable Swart?
No, I support the declarations. It's just also a great challenge for me because I'm a whip and I've got to be in the House when we have meetings at the same time. It's also the whip's the programming meeting did make mention of the bills. They're not on the program yet. In fact, the criminal law bill was taken off because that was on the program for Tuesday. But they did indicate in the programming committee that they are expecting the GBB bills to be on before the end of the term. But I do agree with you that there are some very complex issues that we need to fully appreciate the unintended consequences. And whilst we've come a long way, I think we need to exercise great caution. As we've seen, there are drafting implications, and today the issues around the register can take some time to finalize. And I don't think we must put so much pressure on the drafters, given the fact that it's at a very late stage. So let's assess as we're going along, Chair, and you can rest assured we will all support you if we reach the stage where we have to justify that we're not concluding the bills at this stage. But I do understand from the whippery, there's a lot of pressure for us to finalize. Thank you, Chair.
Thank you very much, Honorable Swart. And then on the issue of declarations, what is the view of the ACTP? Whether we should...
I fully support the view that we must have a full debate on the issue, Chair. Declarations.
Even Swart, I know where you live.
Declarations, Chair. Thank you.
Declaration. So I nearly had a heart attack that Honorable Yak was influencing you in a wrong direction.
Yes.
And infiltrating this committee. Sniper.
And I know you're in Cape Town.
You don't know where I live though.
But Chair, you must also comment about Honorable Swart. Today he was not serious. He was different. Please comment, Chair.
I appreciate that. Thank you so much.
Yeah.
I'm not sure about it being different. What does it mean?
He would come in just like we do. He's always serious. He's always, not like joking. You see now he has just made a joke about.
He received breakfast, perhaps.
Yes.
It's Friday afternoon. Is that too much to drink?
You wish. You wish. Still, I've got lots of work still to do. Thanks. Have a wonderful weekend.
Thank you very much.
I really want to maybe encourage what I saw him doing, to send information so that we debate even outside of this and look forward to be having, better ways of dealing with things. I think I appreciate actually what he has sent, because I'm a Christian. Even if I'm a member of the ANC and a Christian, I'll be able to engage those that are in the spiritual side. And thank you. We'll look at each other on Tuesday again. But I really appreciate and thank you, Mr. Honorable Swart.
Well, thank you very much, and thank you to all.
I appreciate that as well. Thank you.
And thank you to all members for the spirit you always display. We take our work very seriously, and we always put an extra effort to ensure that we give the best to our South African compatriots, and thank you very much for that. We know that this term has been very, very difficult. You were asked to go beyond the call of duty, and you rose to the occasion. Thank you very much to our supporting staff and to all the organizations that have always made it an effort to ensure that they come and watch our committee. They also give very useful feedback so that we are able to get guidance. Thank you very much for to support staff from Parliament, from our committee. Thank you very much. The meeting is adjourned. We might meet early, 8:30 on Tuesday, because we want at least to have a brief meeting to look at the questions, and then before the first candidate, we start with the first candidate. Thank you very much. Enjoy what is left of a Friday till we meet again.
Thank you.
Okay.
Thank you, Chair. Bye.
Bye bye.
Thank you,
Thank
Chair.
you.
Blessings to all.
Thank you.
Amen.